Hello friends, today we are going to discuss about capacity assessment. I'm Dr. Suresh Badadmat, Professor of Psychiatry working at NIMANS, Bangalore. Before I start my presentation, I would like to have a disclaimer. This presentation is for academic and training purpose only. This presentation is not an alternate for legal opinion. For legal opinion, please do contact an advocate. Conflict of interest? None. In this video, I'm going to discuss about the concept of capacity, legal implication of assessment of capacity, when to assess, how to assess, and who is going to do the assessment. This video is relevant for psychiatrists, medical practitioners, and mental health professionals such as clinical psychologist, psychiatric social worker, and psychiatric nurses. People employed in mental health review board, and also the members of state mental authority and central mental health authority will benefit by watching this video. At last, not the least, patients and the patient's family members also benefit by this video to understand the concept of capacity. Let's understand what does capacity means. All human beings by birth, they are free, equal, and autonomous. And they can decide about their body, how it has to be treated. That is right to self-determination. So a person can decide about himself. But with regard to mental illness, whether he can decide about himself or not, whether he can enter into a contract or not. So that capacity to decide by himself is the point of contention here, what we are discussing. Because right to self-determination is a basic human rights. And in persons with mental illness, you are going to tell that you do not have right to self-determination, somebody else will do decision for you. It may be his family members, it may be his friends, or else a third person who will take a decision, that is proxy decision. Is it right? Before we do this, we have to assess his capacity to decide, that is decision-making capacity. Let's understand about the decision. A decision, a choice that you make about something after thinking about several possibilities. That is very easy to understand. Coming to the point of contention, the capacity. The capacity is ability to do a particular thing. And coming to a specific mental capacity is the ability to make a particular decision at the time it needs to be done. And it is relevant to time. It's very essential. So, capacity and mental capacity go in hand. Capacity is a clinical construct decided by a clinician, and it is task specific. And it's a spectrum. It is not an all or none phenomena. Whereas competence is a legal term decided by the court, and once the court decides this person is incompetent, he cannot enter into any legal valid contract. That means he becomes legally invalid. Nobody can enter into contract with him. If they enter into a contract with him, that contract is invalid. And the court has to come back and say, yes, this person has regained competence. Then only he will be able to vote, he will be able to enter into a contract. Whereas capacity, being a clinical term, clinician is assessing it, and it is a spectrum, and it is task specific. It is highly dynamic in nature. For example, a person with schizophrenia is able to decide that what breakfast is going to have today morning may lose his capacity the next morning because of severe recurrence of his symptoms. And by starting treatment within 3 days, he may regain his capacity. Here, the clinician will do the assessment. There is no need of the court to come and say, yes, he has lost capacity now, and the next day he has regained capacity. So it's being a clinical construct, the clinician will be deciding. Hence, it is also considered as specific task at specific time. That is highly dynamic in nature. Today, a person has decision-making capacity. After few days, he may have a mental illness and he may lose that decision-making capacity. Once the treatment is started, he regains the capacity. However, whenever this being spectrum construct, there in certain periods, the person with mental illness requires assistance to take decision. That is called as assisted decision making or supported decision making. Hence, loss of capacity is a temporary phenomena. By treatment, it can be regained. Hence, there are certain conditions the capacity is lost temporarily. In certain cases, it may be permanent damage may be there. So, capacity being a clinical construct, my dear friends, assessed by a clinician under the Mental Health Care Act of Section 4. Now the question is, capacity, does it equate to a diagnosis? Sorry. Psychiatric diagnosis and capacity does not equate. That means a person with social phobia, a person with depression may have retained capacity. A person with substance abuse has capacity. That means diagnosis does not equate to capacity. Absent insight does not equate to capacity. Again, a person who is using alcohol daily has a dependent pattern may not consider that he has alcohol related problems. Insight is absent, but he can enter into any contract. His capacity is preserved. Coming to the cognitive impairment or memory loss, again does not directly equates to capacity. Look into the Section 4 of Mental Health Care Act. I will come into it shortly. Wrong decisions does not mean he has incapacity. A person with mental illness is allowed to decide and make wrong decisions. Being on psychiatric medication does not mean that he does not have capacity. Poverty, looks does not equate incapacity. At the same time, educational qualification does not equate to capacity. So these are the various factors which has been considered by various psychiatrists that having a certain diagnosis means it is incapacity or he has capacity. So it is independent construct and it is clinical construct, and it requires three important criteria to say whether a person has capacity or incapacity. One is comprehension, appreciation of risk, and communication of the decision. Let's understand what is decision-making capacity. Decision-making capacity means if a person can demonstrate understanding of the situation, appreciation of the consequences of their decision, and reasoning in their thought process, and if they can communicate their wishes, that means that person has decision-making capacity. With regard to patient, if I want to translate the definition, ability of a patient to understand the benefits and risks of and the alternatives to a proposed treatment or intervention, and also includes if there is no treatment. Again, the same decision can be transferred in terms of treatment in a hospital setting. Let's understand the decision-making capacity concept. In this diagram, you can understand the capacity is a spectrum concept. On one extreme, it is a rights-based decision-making. For example, with regard to marriage, a person will decide he will marry whomever he likes or loves, irrespective of the parents' decision. That is rights-based decision-making, love marriage. On the other extreme, it's a proxy decision-making where arranged marriage takes place. Here, the parents will decide whom he or she is going to get married. There is no choice is given to the person. That is proxy decision-making. However, in reality, it is shared decision-making, supported decision-making occurs. Here, the parents will search for the groom or the bride, and then the choices will be given to the person. And the whole family as a unit sit together and they decide, and a shared decision-making is done. That is love cum arranged marriage. That is the reality in India. Is shared decision-making or supported decision-making is the way to go. One more example I will give you. If a doctor decides to go for surgery and he says to the patient, I would like to do a surgery, the patient will immediately say, let me talk to my family members. And the family as a unit will decide about the surgery. And finally, the person will give consent. Again, here the shared decision making or supported decision making is the way to go. One more example I would like to give you here. You being a doctor would like to buy a house. How do you decide? What are the support system you are going to take the decision how to buy a house in Bangalore? You will talk to your family members, you will talk to your friends, relatives, you will talk to the brokers, you will talk to an advocate for legal opinion about the property. And finally, you may talk to a bank to take loan. Again, from the bank, you will take an advocate's help to know about the property's condition and the legal status. That you being a doctor wants so much of support to decide whether I should buy this property or not. That means, again, here it is a supported decision making. You being a doctor required a support. Similarly, a person with mental illness required support or assistance to decide. That is the way to go. That is what we call it as supported decision making or shared decision making, not the proxy decision making. However, in India, rights-based decision looks very attractive, but the reality is assisted decision making or supported decision making is the way to go, because ours is a collective rights. The family as a whole, we decide about a person's with mental illness. The state's responsibility in providing treatment is very minimal. It is the family members, father, mother, those are the people who take care of the patient. Hence, the collective rights prevails over the individual rights. This is my personal opinion. The legal implication of this capacity is all capacity is the basis for informed consent. If a person has capacity, the informed consent becomes valid. If the person doesn't have a capacity, that informed consent, if you are taken, it becomes invalid. Hence, capacity assessment is a must, especially with persons with mental illness. That means, should capacity to be assessed every time when you take consent? Let me be very clear. The law doesn't say that. The law clearly says every person with mental illness, irrespective whether he is suffering or not, has capacity. That is section 4. I'll read that. Every person, including a person with mental illness, shall deem to be have capacity to make decision regarding the mental health care or treatment is the word. That means by default, every person has capacity. If you decide to do something against the persons with mental illness choice or his will or his consent, that means the persons with mental illness choice has been violated. That means you should have a strong reason. You should have done the capacity assessment. Then only it will hold good in the court of law. Otherwise, it will be considered as you have violated the informed consent. The penal provisions will be there against you. Let's understand the capacity to consent under Section 4 of Mental Health Care Act. There are 3 components into it: understanding the information, appreciation of the information, weighing the risk and benefit, and finally communicating the decision. First, understanding the information that is relevant to take a decision on the treatment or admission or personal assistance. With regard to appreciation of those information what he has got, whether he should accept it, reject it. What is the benefit? What is the risk involved? What is the benefit of not taking treatment and risk of not taking treatment? So these, if he's able to appreciate the risk and is able to communicate the choice, that means he has capacity. And you do not have any business to treat him against his wish and will when he has capacity. When he has capacity, the informed consent is very essential. Again, one more point the law clearly says under Section 4. Wrong decision or inappropriate decision does not equate to incapacity. If a person with mental illness takes a wrong decision, that doesn't mean he doesn't have capacity. If he is able to fulfill these 3 criteria of comprehension, appreciation of risk, and communicating the decision, that means he has capacity, irrespective of what choices he makes, whether it is a wrong decision he makes. Let's understand decision-making capacity for what purpose? Especially with Mental Health Care Act, it is regarding admission, regarding treatment, assessment for mental health care, whether he has to be discharged, for making advance directives, and nominated representative. For these purposes, the capacity assessment is done under Mental Health Care Act. Please do remember, Mental Health Care Act does not talk about property, guardianship. That means mobile and immobile property related decision making is not covered under Mental Health Care Act of 2017. It is covered under the Right to Persons with Disability Act of 2016 under Section 14. That is right to provision of guardianship, where it discusses about limited guardianship and plenary guardianship. So we will not deal with this. I'll be taking a separate video with regard to guardianship, especially with persons with mental illness. How to assess for capacity under Mental Health Care Act of 2017? As per Section 81 of the Mental Health Care Act, a guidance document needs to be prepared by the expert committee for the purpose of assessment of capacity by the mental health professionals. And very clearly, Section 81, subsection 2 clearly says that every medical practitioner and mental health professional should comply with guidance document to the procedure to be followed as per the guidance document. Who should assess the capacity? As per the Mental Health Care Act, psychiatrist, medical practitioner who is allopathy, Ayush and homeopathy is allowed, psychiatric social worker, clinical psychologist, mental health nurses, and having postgraduate degree in psychiatry under Ayush is allowed to do the capacity assessment. An expert committee was constituted under the Mental Health Care Act, Section 81. These are the members. The chairman was Professor B.N. Gangadhar for this capacity assessment document. There are various stakeholders who have been called for the expert committee. This expert committee dealt with and came with the guidance document. NIMHANS played a crucial role along with HIBAS and AIMS with regard to development of guidance document. Now, when this guidance document was drafted, there were a lot of challenges. One of the challenge was, should we make a very comprehensive document which is complex? Should it be time consuming? Or else it should be simple, should not be exhaustive? Should it be structured or semi-structured? Or it should be an open document? How much should we codify in the guideline? Should we allow clinical decision, the professional decision making, autonomy to be allowed or not? These were the questions put forward before the committee. The committee went ahead considering the number of professionals, mental health professionals in our country, considering they are very few in number, and also the number of people need to be treated are huge in number. We brought a practical, pragmatic guideline which can be very easily administered on OPD basis. And also clearly, the whole team clearly said that it should be simple, it should be semi-structured, and clinical autonomy should be there. Let's look into the various principles of capacity assessment as per the Mental Health Care Act. As for the first principle, the presumption of capacity is by default. Every person with mental illness or a normal person, the presumption of capacity is by default. Unwise decision doesn't mean that he doesn't have capacity. This is the second principle. A mental illness does not equate to capacity. That means capacity being an independent construct. Whether the person has comprehension, appreciation of risk, and is able to communicate, that is capacity. Just because a person has mental illness does not mean he doesn't have capacity. Least restrictive environment should be enforced whenever a person doesn't have incapacity. That means if a person with mental illness lost his capacity, he has to be treated in a least restrictive environment is a very important principle. Further, best interest principle of persons with mental illness. Whenever mental health professional decides this person doesn't have capacity and the NR is making a decision, and it should be in the best interest of a person with mental illness. These are the very important 5 principles needs to be kept in mind whenever you do capacity assessment and provide mental health care. Let's understand, when should we assess the capacity? What are the triggers? The triggers as per the Mental Health Care Act are capacity to make mental health care treatment decision. Assessment should be carried out in all persons with mental illness above 18 years. Below 18 years, they are children. The NR or the legal guardians or the parents will decide for them. Above 18 years, these are the triggers you should keep in mind. Whenever the registration of advance directive is done, whenever a person's advance directive is invoked, then the capacity assessment is done. Independent admission, whether a person has capacity so that he can get admitted to a mental health establishment independently and stay alone and give consent for admission and treatment. Again, the capacity assessment is done here. However, there are many people who have criticized having independent admission. The capacity assessment should be done. How can it be done? Because it is an independent admission. But however, a psychiatrist, when he has to admit somebody and he has admitted, tomorrow a person may go around and say, I was mentally ill. I was getting admitted and my consent has been taken. A person's with mental illness consent, how can it be valid? Hence, to have a consent, it is valid. The capacity should be there. And clearly, Section 86, subsection 2C clearly says that capacity should be preserved for a person who is getting admitted under independent admission. Not only that, there are many certain conditions as mental illness. For example, catatonia. A person may not give consent at all. He will be sitting mute. He may not be able to give any kind of opinion or consent. The psychiatrist may suddenly say, I will be admitting him as involuntary or voluntary and go ahead with the treatment. Here, the consent becomes invalid, though the patient did not refuse for admission or treatment when the person has catatonia or else severe negative symptoms. In such a scenario, the capacity assessment becomes mandatory even if it is an independent admission. This is as per the law. Supported admission as per 89 and 90. Here the capacity assessment has to be done before you admit them. At the same time, under Section 89, every week you have to do capacity assessment. If the person regains capacity, the informed consent has to be taken to continue admission and treatment. If the person regains capacity and says, I have to be discharged, you don't have any right to keep that person in the mental health establishment. You should honor his capacity and honor his consent. Even under Section 90, every 2 weeks once, capacity assessment has to be done. And if the person regains capacity, you have to honor his wish. That's what the Mental Health Care Act clearly dictates. Further, before giving information to a NR, capacity assessment has to be done. And if the patient capacity is preserved, the informed consent has to be taken from the patient telling that I'm providing information to the NR. If the patient says don't give information to NR, you don't have any right to give information to the NR. If the patient has lost the capacity, NR has to decide, then the information has to be given. For that, you have to do the capacity assessment. And for other treatment-related decision-making, capacity assessment becomes mandatory. What are the documentation required when you say the person has capacity and you have done the capacity assessment? All professionals and the staffs involved in the care and treatment of persons with mental illness with regard to lack of capacity, the documents need to be preserved for long term. And that is very essential because person with mental illness may challenge that involuntary treatment or supported treatment or supported decision making in the court of law, especially in mental health review board. And that documentation has to be clearly done in the medical records. Further, you also need to document whether there was a language barrier between the care provider and the patient. Imagine if a patient is from Tamil Nadu and he speaks only Tamil and he is admitted in a Karnataka hospital. Here, the professionals speak only Kannada. Just because there is a language barrier, you cannot say that the person speaking Tamil has incapacity. That means language barrier should not be there. And there should not be any other barrier with regard to communication. The patient may have hard of hearing. That needs to be ruled out. Hence, the capacity assessment has to be documented thoroughly. And it has to be documented and kept for a long time whenever you are doing any treatment or admission against the wish and will of a person with mental illness. Further, you have to document who did the assessment, when did the assessment take place, where did the assessment takes place, and who was involved in decision making. What information was provided to the patient, what the decision was taken by the patient, why the decision was made by that patient, what information was given, and what was the reasoning given by the patient, and how the decision was made. All these needs to be documented in the medical record. Now coming to the assessment pro forma ratified by the Central Mental Authority. As per the Central Mental Authority, on 16th of August 2019, a guidance document was released as per the expert committee constituted under the Section 81 of Mental Health Care Act. This is the document. There are important components. The components are demographic details, obvious lack of capacity, understanding the information, appreciation of risk, and communication and decision. So these components need to be assessed. Let's move into each one of them. First and the foremost is demographic details. These are the demographic details which needs to be captured. Name, age, gender, ID, date of assessment, place of assessment, time of assessment, purpose of the assessment, whether it is for admission, treatment, discharge, whether it's for AD, nominated representative, that needs to be done. At the same time, under what section if you are going to admit, that also need to be documented. Whether there is advance directive, NR is there or not, and provisional diagnosis or a definitive diagnosis if you have, needs to be documented. Before we move further, a very important note has to be done. This note is, you need to provide explanation for each of your observation under each question. That means, without giving logical explanation, you cannot make any kind of conclusion. There should be an explanation for each of your observation. Let's move now. Obvious lack of capacity. Obvious lack of capacity means here a person with mental illness is in such a condition that one cannot, that is basically a mental health professional cannot have any kind of meaningful conversation because person with mental illness is violent, excited, catatonic, stuporous, delirious, alcohol and substance-induced intoxication is there, or else severe withdrawal is there. If that is the condition, then you are going to document it. This is the explanation you have to do. Without explanation, you just can't take yes or no. Because if the patient or the person with mental illness, if he challenges in MHRB, you should be able to recollect and the documentation becomes very important. Hence, the explanation has to be given here. If the person has lack of capacity, he will directly go into 4B, where the NR signature is taken and then the treatment will be initiated or the admission is done. Let's move to the second one. If the person does not have obvious lack of capacity, in such a scenario, what will be done? You have to move further. That is point number 1. Understanding about the information has to be done. Under the understanding of information, whether the person is oriented to time, place, person will be checked. If he has, he will move further. Irrespective whether the person is oriented or not, he will do the assessment, point number 1. Point number 2, whether he or she been provided with relevant information regarding the assessment, telling that your parents have been brought to you here and they are reporting these symptoms. And it appears that you have these symptoms and you need these assessments. And these are the possible diagnosis, these are the possible treatment, whether those information is given or not. If it is given, those information needs to be documented. If the information is not given, why it is not given, explanation has to be provided. Further, moving to the C, whether he is able to follow simple commands has to be documented. And the important fourth point is, does he or she acknowledges that he has mental illness or not? That is insight. You're going to document here. Again, just a person doesn't have insight doesn't means he has loss of capacity. Please don't do that. If it is just because he doesn't have capacity, doesn't have insight, you cannot say that he has incapacity. We have not given any jump mechanism here. That means you cannot directly go to 4B here. Here you have to continue with the assessment. Now, Irrespective of his insight, he will continue the appreciation of risk assessment. In the appreciation of risk, the important point is, does the individual agree to receive treatment proposed by the treating team? If it is yes, he will go to 2B. If he refuses for treatment, he will go to 2C. Here, does he or she explains why he has agreed for treatment? And the explanation has to be provided here. Again, if he or she refuses treatment, what is the explanation given? That needs to be documented here. Further, you have to go for the communication. The communication, whether he has accepted the treatment, whether he has refused the treatment, whether he is able to communicate either by speech, writing, or by expression or gesture, needs to be documented here. So these are the important points for assessment. And finally, the mental health professional, depending upon various information, that is interview of the patient, interview of the family member, taking relevant history, behavioral observation, clinical findings, and mental status examination, the mental health professional will take a decision. And the decision may be the person has capacity for taking treatment decision, or else he doesn't have capacity and 100% support is required. If there is a capacity is there, you will go to 4A and you will go for the signature. If the person doesn't have capacity, you will go to 4B. Let's look into 4A. 4A, the capacity is present. The signature is done by the person with mental illness because he has capacity. The consent is taken from the relevant person. If the person doesn't have capacity, NR will take the decision, and it should be a supported decision making, not a proxy decision making. And that has to be documented here, and the mental health professional will sign here. Let me provide you certain anchoring questions for comprehension. Here, you are going to assess whether the person has comprehended the information. For that, you have to introduce yourself and say what is the reason for current interview. At the same time, ask for his whereabouts, his demographic details, how we can help him, what was the reason for consultation, who has brought him here, what do they think about his health, whether he knows that he is suffering from mental illness. And if you are giving certain information, it appears that you are suffering from schizophrenia. Schizophrenia has these kinds of symptoms. These are the treatment choices, and these are the various options. Whether he has understood those information has to be assessed. What treatment was suggested or recommended by your doctor or psychiatrist or by previous psychiatrist? Can you explain various treatment options which you know about it? Can you explain the various treatment options and their potential benefits and risk? So these comprehension questions should be asked. Further, you need to ask for appreciation. Appreciation of the benefit and risk. Appreciation of the treatment he has chosen and the risk of the treatment he has chosen. And what do you believe if the treatment is given to you? What do you believe if the treatment is not given to you, or if you refuse treatment, what are the consequences of it? Further, do you believe there are alternative treatment options available and which you want to consider? How do you decide for accepting the treatment or rejection of the treatment? What makes you choose an option is better than the suggested treatment option? Here, you are assessing for his reasoning capability. That is very essential. Along with this, you are going to assess the communication. How did he communicate regarding the treatment choice he has made? That needs to be documented. So, this assessment guidance is a semi-structured, and you are free to ask any number of questions with regard to comprehension, appreciation of risk, and communication. And this assessment is not a standalone assessment. You need to take into account of the information provided by the family members, his behavior, his mental status examination, cognitive assessments, what treatment he is taking. With all these comprehensive information, you are going to decide whether the person has capacity or he doesn't have capacity. To conclude, my dear friends, capacity has three important components as per Mental Health Care Act: comprehension, appreciation of risk, and communication. And please do encourage for supported decision making, or else assisted decision making whenever you're going to treat a person against his wish and will. Because proxy decision making or surrogate decision making is not appropriate and it is not encouraged under the Mental Health Care Act. Please do remember, family plays a pivot role in providing care. Hence, the decision by the family, along with the NR, with regard to persons with mental illness, prevails. And capacity assessment is very essential under Mental Health Care Act. Thank you very much for giving your valuable time. Stay safe.